The two parties involved in this case are the New York Times and Lester Bruce Sullivan. L.B. Sullivan was a commissioner in Montgomery, Alabama, and sued the New York Times for printing an advertisement about the civil rights movement in the South that defamed him. Sullivan felt that his reputation was damaged by the New York Times because he was a public official in Montgomery, Alabama. The New York Times never mentioned L.B. Sullivan by name, but he claimed that it referred to him indirectly because he had oversight responsibility of the police department at the time. What the article mentioned. The article was titled Heed Their Rising Voices. The advertisement began by stating that, as the whole world knows by now, thousands of Southern Negro students are engaged in widespread nonviolent demonstrations in positive affirmation of the rights to live in human dignity as guaranteed by the U.S. Constitution and Bill of Rights. The New York Times did not release a retraction, but did release a respondent letter saying to Mr. Sullivan, "We are somewhat puzzled as to how you think the statements in any way reflect on you, and you might, if you desire, let us know in what respect you claim that the statements in the advertisement reflect on you." The elements of defamation are that they have to be written down in a newspaper, magazine, or blog. L.B. Sullivan had to prove that the New York Times had actual malice when they released the publication, knew that they were spreading false statements, and disregarded the truth. Defamation is the publication of a false statement about another person that causes that person harm. In an Alabama court, L.B. Sullivan won his case, and the New York Times were ordered to pay $5,000 in damages to the commissioner. Mr. Sullivan proved that the advertisement contained a number of minor inaccuracies about described incidents that happened in 1964 Alabama. Before the jury made their decision in the case, the judge instructed the jury that under Alabama law, if the statements were found libelous, falsity, and malice were presumed, and the damages could be awarded without direct proof of financial loss. The jury concluded that the statements did concern Sullivan and awarded him $5,000 for injuries to his reputation and profession. Alabama law denies a public officer recovery of punitive damages in a liable action brought on account of a publication concerning his official conduct unless he first makes a written demand for a public retraction and the defendant fails or refuses to comply. Alabama Code, Title 7, Section 914. The Times appealed the decision to the U.S. Supreme Court. The newspaper argued that it had no intention of hurting L.B. Sullivan in the statements that they made. The Times had no reason to believe that the ad included false statements, so it did not check their accuracy. The newspapers argued that if a newspaper had to check the accuracy of every criticism of every public official, a free press release would be severely limited. In a unanimous decision in the United States Supreme Court ruled in favor of the New York Times. In order to prove liable, a public official must show that the newspaper had acted with actual malice, that is, with knowledge that it was false or with reckless disregard for the truth. Gertz versus Welch. The two parties involved in this case are Elmer Gertz and Robert Welch, Incorporated. Elmer was neither a public figure or public official. This made him a private person. Neither petitioner's past service or certain city committees or his appearance as an attorney at the coroner's inquest into the death of the murder victim made him a public official. What is a petitioner? The party who presents a petition to the court. On appeal, the petitioner is usually the party who lost in the lower court. The petitioner can either be the plaintiff or the defendant from the court. A brief review of the Nuncio case. A Chicago policeman was convicted of the murder. The victim's family retained petitioner a reputable attorney to represent them in a civil litigation. In 1968, a Chicago policeman named Nuncio shot and killed a youth named Nelson. The state authorities prosecuted Nuncio for the homicide and ultimately obtained a conviction of murder in the second degree. The Nelson family retrained petitioner Elmer Gertz, a reputable attorney, to represent them in a civil litigation against Nuncio. Robert Welch Incorporated attacked the reputation of Elmer Gertz by publishing false accusations and attacked his character as a person. Welch warned their readers that national police were being developed that supported communism. The American Opinion article accused Elmer Gertz of being the architect of a fame-up, Leninist, and a communist frontier for bringing suit against a local police officer who killed a child. The article as well implied Gertz had a criminal record. The managing editor of the American Opinion article made no effort to verify or substantiate charges against petitioners. The magazine appended an editorial introduction stating that the author had conducted extensive research into the Richard Nuncio case. Welch Inc. also included in the article a photograph of petitioners and wrote the caption that appeared under it: Elmer Gertz, a red guild harassed Nuncio responded. The allegations made by Welch Inc. affected Gertz as an individual because he had become untrustworthy in the eyes of the public as well as potential clients. Being accused that you as an attorney yourself has a criminal record jeopardizes your livelihood. If I were Welch Incorporated, I would have made sure that the author who said they did extensive research checked their sources and resources several times before making such allegations. If it were to be true that Elmer Gertz had a criminal record, I would have made that journalists get actual records to show proof of his alleged criminalization. It was the editor-in-chief of Welch Inc. to make sure that their journalists are truthful in every article that they put out, even if that story is a potential eye-catcher to readers. I live in New Jersey, the Garden State they call it. New Jersey elements of defamation are false statements about the plaintiff, communication of the statement by a third party, fault of the defendant amounting at least negligence, damages suffered by the plaintiff. New Jersey follows the U.S. Supreme Court's decision in Rosenblatt v. Baer in determining who is a public official for purpose of defamation law. Under this test, the public official designation applies to those among the hierarchy of government employees who have or appear to the public to have a substantial responsibility for or over control over the conduct of government officials. New Jersey courts have a two-part test for deciding who is a limited-purpose public figure. The defamatory statement must involve a public controversy. When a public figure plaintiff sues for defamation over statements of purely private concern, New Jersey courts require the plaintiff must prove that the statement acted with actual malice toward them. An example, knowing that the statements were false or reckless, disregarding their falsity. Brief review of the Rosenblatt v. Baer case. Respondent, the former supervisor of a county recreation area who was employed by and responsible to 3 county commissioners, brought this civil libel action in New Hampshire State Court against petitioners whose newspapers column alleged criticized the fiscal management. Sullivan versus the New York Times taught me as a journalist that I have to be careful in the words I use in my articles, even if I know the story is not directed to a specific party. Gertz versus Welch taught me that I have to cross my T's and dot my I's several times before releasing any story that I have. I have to always make sure resources and interviews are reputable and relevant to any story. And if there are any accusations in a story, I have to prove substantial evidence.